NACDL is the association of the nation's criminal defense bar.
Good afternoon. I'm Norm Reimer. I'm the Executive Director of NACDL, and I want to welcome you to this, what I hope will be a fascinating discussion. I hope that many of you who are viewing this have had a chance to view the film, The Vanishing Trial. It will be in general release in a few weeks, but those of you who had an opportunity to get a sneak preview, and we know that several hundred have viewed it, I hope you found it enlightening and it's depressing, but hopefully inspiring so that we can take on a tremendous problem in our criminal justice system. And boy, if there was ever a time when we all need to know that the criminal justice system needs fixing, it's right now. The film itself was, to some extent, to a large extent, I think, inspired by NACDL's report, The Trial Penalty, the Sixth Amendment report that we did, and on the loss of the jury trial and how we can save it. At the end of the presentation, we'll have a link so that you can go and see that. We're also going to provide you a link to a fabulous double issue of the Federal Sentencing Reporter that was devoted entirely to the trial penalty. The stories that you saw in the film are all true. There may have been actors involved in some cases because of the situation that these folks are in, but they're all true stories. Eric Wyant, a first-time offender, offered 3 years, went to trial, got 20 years. Sandra Avery, a victim of abuse as a child under the influence of her husband, he got 17 years. She went to trial, got life. Luckily, was able to get clemency, a very rare occurrence. And Chris Young, who turned down 12 years, ended up getting a life sentence, still in prison. And Kevin Ring, who faced enormous pressure, but stood up, avoided the worst of the trial penalty. But all of these stories have lessons to teach us, and are very instructive about what this is. And what I will say is that they are really only the tip of the iceberg of how the trial penalty has thoroughly corrupted the criminal justice system, fueling the fires of disparity and generally undermining justice. The power of the trial penalty infuses the entire system at every phase. And that's what we want to talk about for the next 45 minutes or so. To discuss the film, the report, and the implications of the trial penalty and how we can revive the right to a jury trial, the fundamental constitutional right to a jury trial. I'm pleased that we're joined by two of the most prominent defense lawyers in the nation. Lisa Wayne, an attorney based in Colorado, tries cases all over the country, lectures all over the country. She's a former public defender. You saw her in the film. She's the president of the NACDL Foundation, and she's the former president of NACDL. Barry Scheck, who hardly needs any introduction, is the co-founder of the Innocence Project, which has revolutionized the way that we look at criminal justice. He's a defense lawyer extraordinaire, a professor of law. He's also an NACDL Foundation trustee and also a former president of NACDL. Lisa, I want to start off with you. And I want to describe something that happens thousands of times a day all over the country. And that is that in courtrooms, big and small, state and federal, an individual will stand up to plead guilty, and usually under oath, they will be asked if anybody threatened or coerced them into pleading guilty. In most cases, when they say yes in order to get the plea offer, is that a truthful statement?
So I think that that is one of the most difficult things that the defense lawyer has to do during the colloquy of a guilty plea, is that all of us know that any defendant entering a guilty plea is pleading based upon the pressures, sometimes of the facts of the case, but so many times as to the penalty that that defendant would face if they in fact what they believed is a great risk, not a constitutional right, but a roll of the dice of going to trial. So despite that, every defendant, and once in a while you'll have a defendant who says to a judge, no, 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 I have to do this. I feel the pressure of it, but that's such a rare case. And so the fact that they say it does not mean that they really mean it, but that in fact they're giving in to not taking that risk, not rolling the dice.
Right. In the film, we see the story of Eric, who turns down a 3-year offer and then gets a sentence of 20 years. In your experience, how common is that kind of a geometrical difference?
I think it's very common. I think that the average person who exercises their right to trial is punished for that in this country. We know that in federal court that people are punished because the minimum mandatory sentences drive that kind of situation for defendants in federal court, but many state courts around the country have minimum mandatories as well. And those clients don't really understand until the hammer comes down and they're standing there at sentencing that, oh my gosh, I exercised my right to go to trial and I'm looking at something far worse than I would have if I had just copped a plea, is what we call it.
So Barry, as a law professor, let me ask you to put that hat on, as somebody who thinks about the theory of the law. If an offer is made by a prosecutor, which they believe is a sufficient amount of time for all the purposes of punishment, deterrence, public safety, retribution, what is the moral justification for saying to somebody, simply because they exercise the constitutional right, they should get 5 times, 6 times, 7 times the sentence?
I can't think of one. I mean, it's, you know, the problem we have is that ever since the Supreme Court came down with a decision in the Bordenkircher case many years ago, plea bargaining is the Wild West. There really are very few, if any, controls over how much leverage you can exercise against the defendant in terms of trying to induce a plea. And it really, if the sentence that you're trying to get is disproportionate to what you believe they really did and what would be the proper purposes of sentencing, it just doesn't make any sense. It's not in the public interest. And, you know, in terms of ethical rules, it really, you know, you begin to wonder about it.
And in fact, it's curious to me that judges will stand for this. How do you explain that? How do you explain a situation where a judge, in some states, they know exactly what the plea offer was, and in fact, in some states, they are complicit and they will actually pile on because the person went to trial? How do you deal with something like that?
Well, I mean, let's first, as the movie indicated, there are some judges that can't stand it but are bound by mandatory minimums. Quite a lot of them. You know, the truth is, we're living at a time where so many judges have been inculcated in mandatory minimums, in the fact that if you turn down the plea and you force them to go to trial, that there has to be an extra penalty, that they don't know what the world was like before this existed. And just in my own experience, I can tell you that I was what they call a CJA lawyer in the Southern and Eastern District of New York near the beginning of my career. And I'll never forget the day that the mandatory minimums and the sentencing guidelines came down. And I had to sit with a CJA client, and I could literally say, here's what happens if you go to trial and lose, and here's what happens if you take a plea. And when I said to the client what the mandatory minimums were, I swear he lost all color and he threw up in a garbage pail right there in the attorney conference room. And frankly, you know, I almost threw up with him because this was new. And the truth is that after a while, everybody gets beaten down in terms of the system, and they forget, or if they ever knew what it was like to operate in a system where there were no mandatory minimums, where there were no mandatory guidelines, where judges, the prosecutors and lawyers had a chance to actually try to devise a resolution to the case that fit the crime, that the person really admits to doing, and was appropriate penalty.
And of course, all of this is what's the reason why we have 2.2 or 2.3 million people behind bars, and we're going to get into this a little bit more deeper as we go through this discussion. And that's why millions and millions of people are out on the streets, because the injustice of the system is being revealed through the microcosm of one particularly horrendous situation, but really it's a reflection of something that's been going on for a long time. Lisa, I want to shift back to you, and I want to ask you, a lot of people, we talk about the trial penalty. It isn't just the geometrically greater sentence that one might get if one exercises their rights. It's also used as a bludgeon to get people to give up so many rights. Can you speak to that? This way that it's used to get people to capitulate at different phases.
Well, what happens is if you have a defendant who says to you, I'm innocent, or I'm not guilty of the greater crime, I may have done something less, and you cannot move the government starts from the front end saying, if you don't waive certain hearings, if you file motions and make me work on this, that this case will get greater and we'll move more toward the sentence that would be the enhancement or the top of the end if you make me have to work. And so there's this thing that has happened in the system where people are pleading out earlier. They don't get to litigate their rights. We don't get to find out the things that went wrong in the case, the warrants that weren't executed lawfully, the police that made unlawful arrests or beat up the clients. All of those things are used in terms of this hammer of consequences as you go on in the system. So it starts at the very beginning. Take the deal now, take it early, get out, or we're going to punish you for that.
So Barry, you mentioned already that one of the causes of all of this is mandatory minimums, and Lisa, you've just suggested that at each stage of the case, if you don't give up something, they will threaten to make it worse. But can you give us a sort of an idea of all the different ingredients that are going into this pot that's making this witch's brew, besides mandatory minimums? I mean, absolutely. I think you mentioned, yeah.
Well, I mean, what makes this possible is prosecutorial control of the charging function. When you have mandatory minimums and you have aggravators, there's one thing that you're arrested for, and then there's always the threat of putting you into a mandatory minimum sentence or even charging an aggravator. So that gives the prosecutor enormous control of the charging function. Of course, mandatory minimums that we've mentioned, sentencing guidelines, manipulation in federal court, certainly of what we call relevant conduct, what's going to be put in potentially for purposes of sentencing. Bail can be used literally as ransom, judicial involvement or judicial engagement in this entire process. So few judges are going to get themselves involved, particularly in state court where they really have an opportunity to stop the prosecutors from manipulating the charging function. In federal court, primarily, there's a concept known as substantial assistance. That is, if they're trying to get some cooperation from a defendant in a case, it doesn't really work unless the prosecutor is willing to say to the judge, yes, they're cooperating, but they've also given us substantial assistance. And unless it's formally acknowledged to be substantial assistance, you don't get credit. And frankly, it's an inducement for people to cooperate and not tell the truth.
Falsely implicating people.
Falsely implicating people. And finally, as we said at the very beginning, plea bargaining is a constitution-free zone. The lack of transparency. You can have a prosecutor talking to the defense lawyer and they'll make some kind of a representation about what's going on, and you never get to know exactly what that is. And frankly, they can bring the judge into the bargaining process because there is sentence bargaining and plea, in the course of plea bargaining. So it's extremely troubling, and there's no transparency, and we don't really know what's going on here when these kinds of pleas can be coerced and people are foregoing the right to a trial. And, Lisa talked about the consequences of it. I can just tell you from the point of view of the Innocence Project, we look at these cases where people pled, and frankly, 11% of the DNA exoneration cases, people have pled guilty to crimes they didn't commit. And it's scandalous. When you go to trial and you put the state to its proof, you find out about junk forensic science or false forensic science, fabricated forensic science. You find out about police officers who have crossed the line. That only really comes out when you actually cross-examine people and you have a trial. And when trials disappear because of the trial penalty, the whole system suffers in terms of the integrity of the process and the goal of justice and truth.
Yeah, well, I want to talk a little bit more about that, but I want to stay right now for a moment with just the brazen degree to which prosecutors will exercise these different leverage points. This is a letter that's written by the government as they're getting ready to for trial, and you can all see it, but the government submits this letter to notify the court and the defendant. The government presently intends to seek a superseding indictment charging one of the defendants with a firearm charge. The government does not presently intend to bring additional charges against any of the other defendants. And then the killer sentence right here. The government may, however, return to the grand jury to seek a superseding indictment, refining the charges, including by adding substantive distribution charges with respect to any defendant who proceeds to trial. So it's as explicit as it can get. We saw this in the Chris Young case. They actually, it's a similar sort of thing where they decide to bring up enhancements if a person doesn't. What that means is if they have prior convictions, even for minor convictions, they can invoke these harsh mandatory minimums. How can it be allowed to be so brazen? Lisa, what is your reaction to that?
Well, I think it's allowed to be so brazen because it's allowed, and there has not been enough of a fight back from the judicial, from the bench, that this is inappropriate. Defense lawyers are afraid on behalf of their clients, and they get punished when you have hundreds of cases and you have clients that are being threatened with these kind of extortion kind of deals. And it's just been, everybody becomes complicit in this because there aren't the resources, the time, and the ability to really fight back on behalf of the clients.
So, and I think that point is very well illustrated, especially with the case of Chris Young.
Right.
And I want you to speak to when they use these enhancements as leverage to get people to capitulate to a guilty plea, to avoid the trial penalty. It seems to me that because of our policing practices, that this is clearly one way that the system is absolutely unfair to people of color. Can you speak to that?
Well, I mean, oftentimes the enhancements go to someone's criminal history, and that criminal history is going to be more elevated in poor communities and people of color because those are the people who have contact with the police. Those are the people that are being brought into the system early on for minor offenses to major offenses. And so those contacts ultimately end up being enhancements, and those enhancements end up counting against sentences. Whereas if you are on a college campus violence, and you're in a college town that's predominantly white, kids doing the very same kind of conduct are not having that kind of contact with the police, and therefore don't have the kind of enhancements that you see on these cases. And and I have to tell you, a lot of times the enhancements, one of the things that's important is that they are easy things for the government to prove. So if you have a gun enhancement, meaning someone may have been involved in a big conspiracy with a number of defendants, like Chris was, who is a low-level person, like Chris was, and someone in that conspiracy had guns, then suddenly that client's looking at an enhancement, a gun enhancement. So they are easy enhancements for the government to use against your client, making it very difficult for the lawyers to fight against it in terms of overcoming them legally. And it's just this, and it's discretionary as to the clients. You see these enhancements brought more against poor people and people of color. These enhancements are not generally occurring in cases where you have white collar matters. Sometimes they can be, depending upon the kind of loss that you may be talking about, but generally you do not see those kind of enhancements. So it's the discretion of these prosecutors, and as Barry said earlier, this prosecutorial kind of power that we have in the system that seems unchecked in so many different ways is what really drives this, in my experience.
So, Barry, you touched on some of this before, and I'd ask either one of you to comment on it. There seems to me that not just are we dealing with injustice, but we're really dealing with a tremendous range of costs to society by virtue of a system that stops people from litigating, that stops people from exercising rights. Can you speak to that? How is this corrupting our entire system?
Well, let's just take forensic science to start with, right? So when we wound up at the Innocence Project exposing a lot of junk and fraudulent forensic science, there was a forensic scientist in the state of West Virginia. This was really the first big breakthrough, called Fred Zane, right? And Fred Zane was dry labbing. By that, I mean, he would not even do the forensic tests. And he would come in and say, we can prove that, this is the hair that comes from, the defendant in this case, or this is the serology. He made all these statements. The amazing thing is that in light of that, all these defense lawyers pled out their clients. Nobody went to trial, and nobody then actually was able to expose the fact that he didn't even do the tests. It's an enormous scandal. And you wonder, how could all this happen? Well, it happened. It happened in the state of West Virginia, and it happened in lots of other labs all across the country. I could go into the scandals in Massachusetts, the scandals in Houston, Texas, the scandals all over where the tests weren't even done, or they were done fraudulently, but nobody brought people to trial. And we really, it is an amazing thing, our adversarial system here in the United States. When you actually get a trial and you actually begin calling people to the witness stand and you cross-examine them, you find out when people's constitutional rights are violated. You find those police officers that routinely break the rules. I'm not saying it's all of them, but you don't have to go too far to realize that it is just a few police officers that are willing to break the rules. The good officers, the ones who don't want to be involved in it, it's really hard for them to come out and say, stop, they're lying, this didn't happen. And that never really comes out unless or until you get people on the witness stand and you begin cross-examining them and you get all the documents and you get everything. And the truth is, you don't get everything until you go to trial.
That's right.
It sounds like perversely one of the effects of the trial penalty is that the weaker the case or the more flawed the case is, the more inclined a prosecutor may be to exercise the trial penalty to try to get somebody to give up early. Am I right about that?
Yeah, I think that's absolutely right. And I think, I mean, as Barry points out, when you can't litigate all this stuff, all of these things that would have fallen apart, all the things you would normally get to scrutinize, you can't do because you're giving that up. And I mean, Barry knows this, and Norman, you do too. How many cases we've had that once you start litigating them, all the things that happen. All the things that fall apart, the drugs that aren't in the lab, the drugs that never got tested, the statements that really didn't happen, the interrogations that were bad with witnesses, all the threats that might have happened out there. But if you hadn't been able to litigate it, none of it would have been brought out. And I think that is the frustration of goes to the core of everything.
So I want to ask you a question, Lisa, that it's one of the hardest questions for a defense lawyer. It's a painful question for a defense lawyer to answer. And I'm reminded of Barry's story about that experience when these mandatory guidelines came in and he had to tell the client what he was facing, and they both got sick at the thought of it. I'm going to ask it to you straight. Have you ever advised a client who might have been innocent that they should plead guilty?
That is a very difficult question.
And I'll put a gloss on it. Isn't it your duty, if you know that they may get, they may never see their children again?
Absolutely. So I'm going to take it from the cases that I find the most difficult under this minimum mandatory, and that is sex assault cases. In most states around the country, the sentences are so great. In my state, in Colorado, it's indeterminate, which we call life sentences. And the sentences are so great that many, many times you have clients where you say to them, when they are offered something less that may save their lives, because we're talking about people's lives, or get them a lesser registration or some other consequences, the pressure is great to tell those clients, no matter how good your case is, no matter how much I believe that you may be wrongfully accused, is the risk, do you want to take the risk of going to prison for the rest of your life? And I have had clients who, thank goodness, when I thought great deals have been offered, such as a misdemeanor, opposed to someone going to prison for the rest of their life. And I've said to them, it's a misdemeanor. A lot of lawyers say this. I would plead my mother to a misdemeanor under these circumstances. And I have had clients tell me no. And I have had clients who agreed because they did not take the risk. And so I'm not going to go as far to say is innocent, because I don't know about that. I never make that judgment. But do I think they would be found not guilty? Absolutely. And do I think that they would wanted to avoid the risk? That becomes so personal with a client, and you can never, in my opinion, second guess that as long as they have everything in front of them. But again, if you're talking about life, who would?
And so it almost becomes like a sliding scale. You could say to somebody, you have a 50 to 70% chance of being acquitted if you go to trial, but you have a 100% chance that you're going to get a sentence 5 times greater than what you're being offered.
That's right.
Of course, you have to let them do what they feel is best, but you've got to tell them. Well, I ask you this question because what we do know, thanks to the Innocence Project and all the innocence work that's been done by so many projects around the country, we do know, as Barry alluded before, that innocent people, in fact, plead guilty. I mean, people who are absolutely, demonstrably, provably innocent. I'd now like to show a clip of Rodney Roberts' case. It runs about 2 minutes or so, and I think it's really worth sharing with our viewers.
Getting my fingerprints and everything, thinking that I was just going to be in, be out, or this is not, it's probably a simple assault and I'm gone. So they held me maybe 3-4 days more, and I was like, wow, why am I still here? And they were saying, well, you're being transferred to Essex County, to the county jail. I'm like, for this? And something was wrong from the beginning. And they had already seemed to have sized me up already. And I met the attorney that was assigned to the case. He was a public defender. I said, what's going on? He said, well, you're being charged with a kidnapping, a sexual assault. Now, at that point, I went ballistic. I was like, no, you got the wrong person. I'm here for this. I don't know what's going on. You got the wrong guy. When I finally got to the court, this attorney, he came in and told me that the prosecutor office had a plea agreement for me. I'm like, plea agreement? I didn't even do it. You know, I pled not guilty. I'm innocent. He was just pressure. And he was like, if you don't take this deal, they only offer you 2 years. You'll be home in 2 years. And if not, you know, they're gonna take it off the trial and the judge is ready to give you life sentence if you get found guilty. And I think you're gonna get found guilty. And this is my attorney telling me, this is the one person I had was there to help me. I felt like I was by myself. So I thought that to get home to my son, then my family, and to salvage my life, that the best thing I could do for myself was to plead guilty and fight it once I got home, or and at least I would be home in 2 years and I can fight it from there. When they said they found it, when the attorney told me, I knew that I was gonna win. I knew I was coming home at some point that because I knew I didn't do it. I just needed the proof to show. Innocent people plead guilty not out of ignorance, but out of fear. I mean, you are afraid that you're gonna lose the one thing you want is your life. But that's it. You feel like I cannot handle this lifetime or doing this time for this crime I commit. And if it wasn't for the DNA evidence, thank God, I'll most likely still be sitting in jail. If I didn't have that, if it was just because eyewitness testimony wasn't enough. So if I didn't have that, I would still be sitting in prison trying to fight for my innocence and my release and prove that.
So Barry, is Rodney an outlier? Is he just 1 in a million?
Well, not at all. I mean, 11% of those who have been exonerated with post-conviction DNA tests pled guilty. You know, because logically, you know, it's true for white-collar clients, and it's certainly true for people charged with, you know, rape and murder, which carry life sentences, not the death penalty in the state systems. You know, it's almost logical to take a plea to some extraordinary sentence than get life or the death penalty. One of the in the volume that we've given to people who are watching these movies is the story of Chris Ochoa. Chris Ochoa is a client of ours who pled guilty to a murder in Texas. And it was, he actually was literally kidnapped in a way by a particular detective in Travis County who was known as being, you know, a relentless interrogator. And he grabbed Chris, who was an altar boy, who had no criminal record, who was born in El Paso, and he's there in, you know, Austin, basically, you know, working in a, I can't remember whether a Burger King or one of those fast food places. And they coerced him into pleading guilty to avoid the death penalty. And then eventually they got him, you know, I mean, literally, I mean, it's so heartbreaking to think back on this. You know, he had a lawyer who said to him, you know, you've really got to turn against this other person named Richard Danziger, and testify against him that he was at least involved in terms of a sexual assault in order for you to avoid the death penalty. So he so testified in that case against Zanziger and went to prison. So at one point, when we were looking at his case, because he had written to the Innocence Project and the Wisconsin Innocence Project, the real assailant, a guy named Akeem Marino, wrote a letter, I swear to you, to the Austin Statesman and all of us saying, I really did this. I really committed the murder. You know, Chris Ochoa and this guy Danziger are innocent. And we gave that to the DA investigators in Travis County. And they went to talk to Chris. And Chris kept on saying, no, I really did it. They said, well, you know, the Innocence Project, you know, these people have told us that maybe you're innocent. And he didn't want to admit it because he believed, even when they were talking to him, that they were going to set him up for murder and he would go get the needle. You know, eventually the DNA testing proved that Chris and Richard Danziger was innocent, and Akeem Marino, like he said, was the person who committed the crime. And it was a terrible crime. And, you know, the victim's mother came out in support of him. It's insane I mean, that is one of the terrible byproducts of the death penalty, you know, that this kind of thing can happen. But you didn't ask me, Norman, have I ever had a client who I knew was innocent that pled guilty? And the answer is, unfortunately, quite a few. And I'll tell you why. Because we've had quite a few cases, you know, at the Innocence Project where we demonstrated that people were unquestionably innocent and they did double-digit time in jail. And even after we came up with enough proof to get their convictions vacated, the prosecutors were still holding on to those cases because they didn't want to be sued or they didn't want to be embarrassed, and even if it wasn't a case that was around at the time that they were prosecutors. And they forced our clients to take what are known as Alford pleas. That's a plea where you say the state has enough evidence to convict me, but I will say I'm guilty, or that the state has enough I insist on my innocence, but I know the state can prove me guilty, so I'm essentially saying nolo contendere, or I will plead in order to make sure that I don't get retried. So, you know, how do I deal with this when I have a client that I know is innocent, but says, I'm going to go to trial again? I've already done 25, 30 years. How do I know I'm not going to get convicted? Don't tell me that juries are going to do the right thing. I've already been there when they didn't. So I've seen this myself. By the way, I have to tell you that unfortunately, people that are criminal defense lawyers, you know, in some of these cases where I've worked on it with them, you know, their first instinct is, oh no, we've got to accept, they're offering us a plea, you know, pending the retrial. Any criminal defense lawyer would say, jump on it. And what really has to happen, and eventually they change their minds, because the truth is, a lot of these people that have to make that impossible decision, whether they'll turn down an Alford plea in time served or risk a retrial, they take that Alford plea and then they can't forgive themselves because for so many years they have maintained their innocence. Some of them even, you know, giving up their chances for parole by refusing to admit, you know, that they, you know, they've contended they didn't commit the crime, and you can't get parole unless you admit and show remorse. We've had a lot of clients like that. So it's a pernicious system in so many ways.
So on this whole question, I thank you for pointing that out about the situations where you've literally known that somebody was innocent. But really what I'm getting at is, you know, many alleged crimes involve intent or degrees of intent. There really is no way that a lawyer or anyone else can know for sure. But the system was designed. The constitutional right is intended to give people the opportunity to let a jury of their peers decide. And what's so pernicious about this is the use of this force to prevent people from being able to take advantage of that without being extra punished just for doing so. And when I look at Rodney's story, and I know that both of you will relate to this, what worries me and what has to worry any thinking, breathing citizen is if there is no DNA, if it's not a crime with biological evidence where you can demonstrably prove innocence, how can we possibly know for sure that if we're so tipping the balance that we aren't having people who are legitimately innocent or might have been found not guilty under our lawful system, that they're giving up because of this pressure?
Well, you know what, Norman, part of it is that your client is empowered as the lawyer feels empowered. And, the reality is that race has so much to do with all of this. And when you have people like Mr. Roberts, and I don't know the race of that the accuser was in that case, but you have all of those things that come into play when you're talking about and counseling your clients about going to trial. So you may have a very defensible case, but you have a client who is African American or Hispanic or Asian, and you're in a white jurisdiction, and the client's looking at life for 50 years, and you have a defensible case, but you have to be honest with that client about, no defense lawyer can give a guarantee. And my position is always it's 50-50. It's a roll of the dice on any case, no matter how good or bad. I've won plenty of bad cases because the government couldn't prove it. It's the ones that are the good cases or the innocent clients are the ones where defense lawyers lose sleep at night. And
Right.
You're telling a client, you have a defensible case, you're looking at 50 years, but you're going to get 12 white people sitting up there making an assessment without forensic evidence, scrutinizing white accusers, white witnesses, white police officers. That's a very different setting in terms of what you consider and what lawyers are telling their clients. So there's a lot of extra pressure outside of just the minimum mandatory sentence that hangs over the head of the defense lawyer and the client when you're making a consideration about a plea or pleading guilty to something that you didn't do.
So let's, one of the frequent rejoinders, and I recall being on a panel in Washington, in DC, a few years ago with a judge and making a presentation on these very topics. And the judge was indignant in a sense that he said, well, this is part of our system. We have to have this. And so I think about, first of all, defender offices around the country are overburdened and under-resourced, dealing with way more than they should have to handle. And I hear this refrain constantly. We have to have this, we have to have these, we have to get rid of a lot of cases with pleas or else the system will collapse. But if the system is allowing somebody like Rodney Roberts to plead guilty when he's innocent, or causing people who actually didn't have drugs to plead guilty rather than have their day in court and find out that actually it wasn't drugs, how do we live with that? How can we possibly accept this?
The bottom line is that when you have this unequal bargaining power, so many bad things happen. I invite everybody to look at the Registry of Exonerations and read the Rodney Roberts write-up by Maurice Posley. It's too complicated to go into too much detail here, but just think of it this way. Rodney, as you indicate, as he said, was told, well, your plea bargain is for 2 years here. And if you, go to trial, you could, get an extraordinary penalty. But what wasn't included in that little snippet is that his lawyer told him, oh, the victim of this kidnapping, sexual assault, identified you and even said that she knew you. Now, in subsequent litigation, it came out that when a defense investigator spoke to the victim, and even one of the prosecution investigators, she said that she never identified him. or she didn't remember ever identifying him, and certainly, didn't know him, from the neighborhood or something like that. That's kind of extraordinary. Now, if you go back and you ask, well, did the defense lawyer know that what the prosecutor was telling him was not true, or did the prosecutor denied in subsequent proceedings in Rodney's case that that's what he told the defense lawyer? We'll never know, because as we've discussed before, there's no transparency in the plea bargaining system. We don't know exactly what was said back and forth in order to induce a plea. But you can see it easily, because in this system where everybody gets worn down, right? Where black or brown defendants, have been battered so long, that they worry they're never going to get a break. So if somebody tells them, looks like you're going to lose, even though they say, I didn't do this, they're not going to fight it. Where the defense lawyer is, under-financed, or frankly is suffering from their own, kind of bias. Like, who do you believe? The prosecutor that's telling you it's a strong identification, or the client said, I didn't do it, right? Well, here's the offer, and then all of a sudden there's that moment that every lawyer's been through, where the judge says, okay, you have to, and this is what happened to you, Norman. The judge is very indignant, because at the time of the plea, they say, and you're pleading guilty because you're guilty and for no other reason, right?
Yeah,
well, right. As the defense lawyers, how do we really know that, especially when the client started off insisting, wait a second, I didn't do this, and you don't know. So, we have to do something, and I guess we're going to get to this, where the penalty, right, or for going to trial is regulated and minimized to a point where it's an acceptable thing to, quote unquote, roll the dice with a client who's insisting that he or she is innocent, versus a situation where the chances of, quote unquote, rolling the dice are so draconian, are so crazy, that if you're a sane person, the only logical thing to do is take the plea.
One of the things that I hear too often is prosecutors have all the power. And I really do think this comes back to us as being united as a bar and defenders. They don't have all the power. And I think a good way to change minimum mandatories is that to empower our lawyers out there to go to trial in a united way. And the public defender systems in the country, and there are many good ones doing great jobs and walking lots of clients and getting better deals than the average lawyer out there. But I think that to get rid of these minimum mandatories, we have the power to shut the system down by going to trial. And the problem with the trial penalty that we see is it makes trials disappearing and young lawyers not getting the experience and being emboldened to go to trial. They don't see them as much as when we were coming up in the system. They're afraid of going to trial. They don't have the skills. And so I think what NACDL does and what the foundation does in terms of training lawyers around this country to unite and go to trial and shut down these prosecutors and win these cases, because they can't go to trial on every case. We have the power there. So I don't feel like all is lost. I actually think we can change this. Yes, it would be nice to have them on board. It will be nice to have judges that are in agreement. And there are some judges. I have a judge in the 10th Circuit who is a senior judge, Judge Kane, who's going to get a shout out here, who will say, I'm not going to punish you as a trial penalty. He tells the defendants that on the front end. but he knows that he has the ability as a senior judge and doesn't give a damn what anybody else thinks about that. He's going to do what he thinks is right. That's the unusual judge, but I think that the defense bar can empower judges as well. So I don't give up all hope on this.
Well, I think and that's a good segue, because I want to, first of all, commend Kevin Ring, the president of FAM, and FAM for this incredible film that tells this wonderful story. And we're so grateful to have been a part of this whole process of elevating this issue. But Kevin's case is sort of, it shows both the tremendous amount of pressure, and he was in a position, obviously, to fight and fight and fight. And fortunately, although the government tried hard to hit him with an enormous trial penalty, the judge was the buffer.
Right.
And it seems to me like when we start talking about fixes, we really, and I get what you're saying, Lisa, if more cases were tried, they first of all, prosecutors would do a better job, because they themselves would learn more about the weaknesses of their case. They themselves would understand that a witness may be tremendously flawed and that the case shouldn't proceed. I mean, we've seen this in some high visibility cases. A few years ago, we saw it with the case of Ted Stevens. That case never should never even been charged, let alone taken to trial. But we've got to be able to look for solutions. One solution clearly is we have to untie the hands of judges so that they don't have to punish somebody unduly. But I'm curious to know if between the two of you, if you have other suggestions for what we could tangibly do.
Well, one of them pretty clearly is what's laid out in the NACDL trial penalty report. Although the analysis was only done for the federal system, you can begin to actually do an analysis of what should be the difference between a plea offer and the penalty after trial. And there should be a limit on how much those two can differ. Here's the plea offer, here's the ultimate penalty after trial. There's got to be some regulation on how much of a difference there can be in terms of the sentencing, so that people can actually, quote unquote, roll the dice if they're insisting on their innocence and go to trial. That is critical. And we can't just do it for the federal system where we have better data and we can actually calculate it. We've got to go, as NACDL is trying, I know in the state of New York, and will start in other states, to actually get data and figure out what the trial penalty is in other jurisdictions, so that we can begin to regulate the mandatory minimums and the sentencing guidelines. That's just critical to do.
All right.
Lisa, please go ahead. And I'd also like you to look at it from the standpoint of both attorney and judicial ethics.
So I think, when we're talking about the federal system, we talk about we can get below the minimum mandatory under certain circumstances, like when the defendant cooperates. If the defendant has been a cooperator, was it early on? Are there other things that will allow the judge to get below that minimum mandatory? And usually they leave it, it's in the prosecutor's hands, because you have to go to them to get the cooperation and do all of those things, although there are exceptions. And, I'd like to see that kind of thing happen in the state, though, where you can get under the minimum mandatory by exceptions, and making those certain exceptions that allow the judge, gives the judge more deference. So you saw in the Young case, the judge said, I would have liked to have given him 7 to 8 years. That was remarkable to hear that judge say, if it had been up to me, the conduct that I heard in trial was 7 to 8 years, not life. And if that judge had had the opportunity in the law that you have heard the facts of the case and you believe there should be what we call a departure, or the ability to get underneath that, that would be a great and effective tool, I think, that all state judges around the country would like, but you can't leave it in the prosecutor's hands. The other thing is that was remarkable when you're watching the film is you see the pretend prosecutor sitting there, and all I kept thinking is, how does that prosecutor wake up in the morning and look at themselves in the mirror after an experience like that? How could he have not been moved by Mr. Young's incredible sentencing statement and walked out of there and really been proud? How can you be proud of yourself after you've done something like that? So there has to be a way for us to be able to go to prosecutors and have the ability to have that the defenders have some kind of legal fire behind them to present to prosecutors certain issues or things that they have found out in terms of their investigations, and the things that they can bring to the table that will allow those prosecutors to either take those minimum mandatories off the table or know that in that circumstance, it's unethical for you to go after a low-level person or someone with lower culpability or someone that may be not even should be involved in the case. If you go forward, it is a bar or ethics issue that you're going to have to deal with. And the problem we have is that every defender in this country has cited to a judge the ABA ethical standards of a prosecutor. I can't tell you how many times that's been in a brief or I've stood up and said to a judge, but that's against the ABA ethical standards. And the judges look at you and sometimes they may agree, but there's no consequence for it. There's no consequence for it. And sometimes Barry in the Innocence Project has seen some of these prosecutors have been slapped or disbarred, but that's such a rare case. And I think that if we have this transparency that we talk about and consequences for ethical consequences or whatever for these prosecutors, you might see using minimum mandatories less and less, I think.
There's also when we talk about transparency in the plea bargaining process, we have to know what was the offer, what were the justifications for it, and we have to put limits on what kind of fundamental rights can be waived.
Absolutely.
Can you waive the right to appeal? As you know much better than I do, Norman, there's even been requests by prosecutors to waive your right to seek compassionate release from prison, particularly with respect to the threat of COVID-19. I can tell you that we had for a while a series of cases where prosecutors wanted you to waive your right to a post-conviction DNA test that could prove you innocent when you pled guilty. Think about that one, because they know that there have been at least 11% of cases where the guilty plea goes down and it turns out DNA proves somebody innocent, and that, it's a great embarrassment to lots of people in the system, but it ought to be a lesson. And then finally, I would suggest that one of the things that we can do is we have across the country something called conviction integrity units. And at first, some of them were really good, a small number, and a whole bunch were not that good. But increasingly, with the election of more progressive prosecutors, a lot of these conviction integrity units are much improved, particularly and most importantly, when the people that are in charge of the conviction integrity unit actually have a background of being a defense lawyer, because then cognitively they can see the other side. But one of the things now that Fair and Just Prosecution, a group of progressive prosecutors and conviction integrity units that we work with in the Innocence Project, the Innocence Network, we recognize that conviction integrity also entails looking at the sentence that somebody got. Because the truth is now, as these mandatory minimums come off the table and we go back and we look at the sentences that people received in the past, we can see that they're excessive. And there should be provision in the laws in states. Some states have passed these statutes, and certainly within prosecutor offices, there ought to be in conviction integrity units or some division of a prosecutor's office people that would actually go back and look at the sentence and decide whether it's excessive. My colleague Rachel Barkow from NYU Law School has written quite persuasively about a way that one can do an empirical analysis of this, and it doesn't represent a threat to public safety, because the truth is, when people have been in prison for a substantial number of years, they literally present no threat. People age out of crime. We know this. And I'm glad to say that certain offices around the country are actually taking this up as a conviction integrity principle, and that's something that we can do.
That's certainly a step in the right direction. I would also suggest that second look legislation, which would give individuals the right to go back to a court to have their sentence reviewed after a certain period of time. I mean, we have completely lost all proportion with the kinds of sentences that we mete out in this country, frequently for nonviolent offenses, although violent offenses should not be excluded either. If violence is a term of art and behavior is something that changes as people grow up. So we certainly want to do that. And the other thing, of course, is, and I know Rachel Barkow agrees with this as well, we need to have a much more robust use of clemency. The executive branches of the state governments and the federal government, with the possible exception of the Obama initiative, which could have gone a lot farther, but did go farther than anyone had seen in many, many, many years, is another opportunity to try to get relief for people who are suffering under these disproportionately long sentences. I just want to wrap it up by observing that, when we knew we were going to be previewing the film at this particular period of time, of course, we didn't know about the events that would be gripping the nation. And at one point, I sort of thought, well, this is going to overshadow the Vanishing Trial and what we're trying to bring out to the public's view about the trial penalty. But, they say that sunlight is the best disinfectant. And the truth of the matter is that this is one side of the criminal justice system that has been hidden, as you said, Barry. It's a constitution-free zone, what goes on in plea bargaining. And the weapons, Lisa, that you've described, that prosecutors use, these bludgeons, this needs to be exposed. We need to tell these stories so that we can eventually start taking the steps that both of you have identified to remediate the situation. And I think that we are in a time now where the public, a lot of people in the public of all different persuasions understand now that the system is unjust and it needs to be corrected. So I want to extend my congratulations again to FAM for the film. I want to extend my appreciation to Lisa Wayne and Barry Scheck. And I want to just close out. You should be seeing on your screen a link to read the trial penalty report that I mentioned, the special federal sentencing reporter issue. By the way, Chris Ochoa, who Barry spoke so compellingly about the travesty that happened in his case, he wrote an article about his experience and what led him to plead guilty even though he was innocent. And I also want to let everyone know, and if there are lawyers out there who would like to volunteer, NACDL now has a federal trial penalty clemency project. We are looking to identify cases like Chris Young's that someday some president will look at and say, you know what, this is an injustice, we have to correct it. So with that, thank you all for participating, and let's revive the right to a trial by jury in this country. Thanks very much.
Thank you.
Thank you.